Okay, so last time we discussed Article 3 up to Section 11. Okay, now we will discuss Section 12. Are you listening? Can you hear me?
Yes,
Yes,
sir. We can
sir.
hear
Yes,
you,
sir.
sir.
Yes,
Okay.
sir.
So Section 12 of Article 3 of the 1987 Constitution talks about that any person under investigation for a commission of an offense shall have the right to be informed of his right to remain silent. Okay? Take note of this, and to have a competent and independent counsel, preferably of his own choice. If the person cannot afford the services of a counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of his counsel. We call this as the Miranda Doctrine. It originates in the case Miranda against United States of America, where the accused was imprisoned and he is not aware of the case filed against him. So his right was deprived because a case is filed against him, but he cannot defend himself because he was not informed of the nature of the accusation. That is why the right to remain silent is informed to the accused, because if he keeps on talking, that word he uttered may be used against him. Okay, so that right to remain silent is constitutional, and he also has the right to ask for a counsel at his own choice. If he cannot provide a lawyer, then the court will provide with one. Can he defend himself without the counsel? Yes. Okay. If he is a student, a law student who can defend himself, where he is knowledgeable in basic um, rules of court. Okay, the general rule is that these rights cannot be waived, meaning you should always have a counsel. That right cannot be waived except when there is a counsel. There is a lawyer in your presence that you're going to waive that right without a counsel, and it must be in writing. So take note of that. Can a person defend himself without a lawyer? Generally, no, except if in some court will allow, if in the case of Marcos, where he defended himself because he's a law student at that time. Okay. The general rule is that a person cannot defend himself. Okay, because the Constitution provides that he will be provided with a competent counsel at his own choice, and that right cannot be waived except in writing and in the presence of the counsel. Okay, so what does the right to remain silent mean? Okay, that is a word uttered actually by a police officer upon arrest. Okay, that upon arrest, the police officer will say to you, if they cannot memorize this one, they put it in their wallet and they're going to read it to the accused. That he is the counsel, he has the right to remain silent, and if any words he say might be used against him, and he has the right to have a counsel, preferably of his own choice. If he cannot afford, then the state will provide him with one through public attorney's office, and that right cannot be waived except in writing. And the court will only allow if the accused knows the rules of court, and fortunately or unfortunately, only those law students in the senior level, third year or fourth year, who probably knows the law, the legal the procedure, may be allowed. But generally, a person cannot defend himself. We call that defending himself as in sui. It is one of a kind, or okay, in his own behalf. Now, no torture, force, violence, threat, intimidation, or other means which vitiate the free will shall be used against him. Okay, secret detention places, solitary or incommunicado, or other similar forms of detentions are prohibited. Because torturing, forcing a person to admit, if you enforce or if you compel them to do a thing that against their will, the result is that it is not them who actually did it. So they are not the author of their acts. If they're not the author, then it is not voluntary. Therefore, it cannot be admitted in court. Number 3, any confession or admission obtained in violation of this section, of section 17 hereof, shall be inadmissible in evidence against him. Okay, so this refers to torture. The law provides for penal and civil sanctions for violations of this section, as well as compensation and rehabilitation to victims of torture or similar practices and their families. So if the police officer or any person who enforce or apply this one to the accused will be not only criminally liable but also civilly liable. If the person is dead, then the family may receive the damages as a compensation for death. Now, we go to when is this waivable, okay? So Article 3, Section 12 are available when during investigation, okay? If a person is under custodial investigation, he has the right to have a counsel. And the meaning of custodial investigation is when you are interrogated in relation to the crime. The admission thereof without a counsel or the statements uttered without the presence of the counsel cannot be admitted in court. Okay? But prior to custodial investigation, when you are asked on a particular circumstance which would lead to a commission of the crime, and you admitted prior to the police officer's investigation, that can be admitted in court. But if the police officer interrogate you already in relation to the crime committed, not general statements like names of persons, which is not under custodial investigation, if it is already particular to the commission of the crime and it is done without a counsel, that admission cannot be admitted in court. But if it is voluntarily uttered, meaning although the police officer is so quiet, didn't ask you anymore, but you continuously, without interruption, state the facts, then that can be admitted in court because you are not under custodial investigation. So take note of this word, custodial investigation. Okay, because this refers only to the time when the police officer asks you facts in relation to the commission of the crime. But if the question is not in relation to the commission of a crime, like general information, like when was it committed, or the persons involved, who are those, if it has no relation, if it's only a general statement, then it is not under custodial investigation. Any words uttered, therefore, it can be admitted. Okay? But if it is already on a particular circumstances that would lead to the commission of a crime, then the interrogation would fall under custodial investigation and the admission cannot be admitted in court if done without a lawyer. I hope that is understood. Now, there are cases when out of eagerness, the accused would mention the circumstances, okay, in front of the media. That is admitted in court. Why? Because it is not under investigation. The word custodial investigation is only when the police officer wanted to ask information that is in relation to the commission of a crime. Okay. So that is the time when lawyer is needed. Prior to that, lawyer is not needed. Okay. So what are the rights being waived? The right to remain silent, the right to counsel. Rights that cannot be waived, right to be informed of his right to remain silent and to counsel. The right to counsel when making a waiver must be in silent, to remain silent or to counsel. Now, we go to section 13. Okay? So, the very important part of section 12 is the word custodial investigation. Take note of that. It's only when the police officer wanted to ask you the nature of the crime, when it points now to particular circumstances which would lead to the commission of a crime. If done without a lawyer, then that admission cannot be admitted in court. The confession cannot be admitted in court. Why? Because there was no counsel. Okay, so any question in relation to the crime must be in the presence of the counsel. Now we go to section 13. All persons except those charged with the offense punishable by reclusion perpetua or when evidence of guilt is strong. Okay, evidence of guilt is strong and the punishment is reclusion perpetua shall therefore be bailable or released on recognizance as may be provided by law. The word that you're going to understand here is offense punishable by reclusion perpetua. Now, in the hierarchy of the penalty under the revised penal code, the highest is death before it was abolished, but now there's no more death. Then the next to that is punishable by reclusion perpetua, meaning it is still the highest. An equivalent of that in the special law is the life imprisonment. Okay? So the hierarchy of punishment is actually stated in the revised penal code, which is the highest is death. Now there's no more death. Those who are punished by death will now be penalized by reclusion perpetua. So if the penalty imposed is reclusion perpetua like murder or rape with homicide, then it is not, the bail is not available. And second to the, when the penalty imposed is reclusion perpetua, for a while, there are 6 people waiting. I have to admit all. Okay. The evidence of guilt must be strong, because even if the penalty imposed of a crime like parricide, okay, in the case of course, a famous case, okay, a congressman who killed his own wife, which is a parricide, may can file a bail when the evidence of guilt is not strong. But if the penalty imposed is reclusion perpetua, like parricide, killing with the members of the family, or homicide with rape, or then and the evidence of guilt is strong, then bail is not a right. The judge will not accept any bail. In fact, the person accused cannot cause a bail. Okay, so before conviction, bail by sufficient sureties, meaning the certain amount. If it is not strong, then you can post bail or even be released by recognizance. Recognizance is an assurance by politicians like mayor that you will be present during the trial. The right to bail shall not be impaired even when the privilege of the writ of the habeas corpus is suspended. The writ is a privilege actually. Okay, the writ of habeas, it simply means that I have a body, meaning that you cannot be arrested without warrant. During the suspension of the privilege, take note, declaration of martial law cannot automatically suspend the privilege of the writ of habeas corpus. Okay? When I say habeas corpus, it simply means that I have a body. You cannot be arrested without warrant. Okay? The bail shall not be impaired even when the privilege of the habeas corpus is suspended. Even if there is a martial law, bail cannot be suspended. Meaning you can, even if you are arrested without warrant, which is allowed in the declaration of martial law, but you can still post a bail. Excessive bail shall not be required. What do you mean by excessive bail? There is actually a computation in the imposition of bail. One of that is the capacity of the accused. If he is a farmer, of course, he cannot pay higher bill. The nature of the offense committed, okay, and the penalty. The right to bail is its purpose is to uphold the stand of a person is presumed innocent until the proven guilty through due process of law and to avoid unlawful detention. I still have to admit other students. Admit all. I pressed one before. I admit all. I didn't. Okay. I'll check enable waiting room, meaning you can now be admitted even if I will not admit you. Okay, automatically you are now joining. I forgot to click it. Now, what do you mean by bail? Bail simply means security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before the court, or required under conditions specified under the rules of court. It simply means an assurance that you will be present during the trial. In a form of money, if you don't have money, well, if you have a property like land, titled land, that can be a security that you will be present. Otherwise, it will be forfeited in favor of the accused for the future payment of damages in case you lose the case. Now, when is bail discretionary or when is it a matter of right? Okay, if the penalty imposed is less, then at all times, if it is not punishable by death or reclusion perpetua, then before conviction in the RTC, it is a right. Okay, so upon conviction by the RTC, but after the conviction of the RTC, as distinguished that from MTC. MTC decision before its conviction is always a matter of right, meaning you can always post bail because those crimes decided by the MTC is not heinous crimes. Those are bailable. Okay, but crimes convicted by the regional trial court, which is punished by reclusion, punished by 6 years and above. Okay, it may be a discretionary, meaning the offense is not punishable by death or reclusion perpetua. Okay, if it is not punishable by death or reclusion perpetua, because these are non-bailable. These are the only non-bailable, meaning you cannot post bail except again if the evidence of guilt is not strong. Okay, although the penalty is death or reclusion perpetua, but the evidence of guilt is not strong, then a person may still post bail. Now, when there is already a conviction of the RTC, okay, except crime punished by death or reclusion perpetua, the court may allow you to post bail. It is not your right, but the court may grant or deny the bail if it is decided by the regional trial court. For the municipal trial court, all cases decided is always bailable. The court or applicant may admit the accused to bail. The court, in its discretion, may allow the accused to continue a provisional liberty after same bail bond during the period of appeal. Now, when are those, what are those circumstances when the court will not allow, although this is discretionary, meaning may give you, may grant the bail or may deny, but the court will not grant. Okay, this is discretionary, but the court sometimes will not grant for some reasons. What are those? If the accused is recidivist, a quasi-recidivist, or habitual delinquent. Recidivist simply means that you committed a crime while another crime is pending in court, or while there is conviction. Okay, or at the same penalty or title of the crime in the revised penal code, you committed another offense within the same title in the revised penal code. Example, robbery, and then another theft or a crime related to that, then that is delinquency, meaning you commit the same offense of the same title or crime related to it, or has committed a crime aggravated by circumstances of reiteration. Okay, what then by reiteration? You committed the same offense. Okay, while there is still while the penalty imposed is still valid. The accused is found to have previously escaped from legal confinement. If you escape or evaded sentence, or there's a conviction but you escape, or has violated the conditions of the bail, now, so there are standards, as I have mentioned. Okay, there are 10. So there are also circumstances when the bail is denied. Okay, this is the one charged with reclusion perpetua and evidence of guilt is strong. Okay, as for the duration of penalties, okay, there are the list. Okay, the highest is death, followed by reclusion perpetua, reclusion temporal with the corresponding years, prison correctional, arresto mayor, arresto minor, and then 14. No person shall be held to answer a criminal offense without due process of law. This is the second time the due process of law is mentioned. All criminal prosecutions, the accused shall be presumed innocent until the contrary is proved. The time when the person is declared innocent or guilty is only when the court decides that you are indeed guilty or not guilty. Prior to that, you are presumed innocent, which is why a media man cannot make a comment. Otherwise, they will be violating this provision. Okay, if the case is pending, no one is allowed to make comment. Otherwise, there will be sub judice. They will be violating sub judice rule, or when the court is still about to decide and yet you are now publishing that the person is not guilty. In fact, there are media men who are accused of this one because they publish already the decision of the court. It is prohibited because this will influence the judge in deciding the case. The judge may not be biased anymore because the media, the radio or television already published the guilt of the accused. Now, the video might end because we only have 40 minutes, but there are still discussions there are still provisions which I'm going to discuss. If this stops, then we'll just be saying again next week. But we have to answer all the exercises so that every time we meet, it's easy for me to discuss. Now, there is a rule here. In the absence of when the evidence of guilt is equal, then the accused should be acquitted. Okay, take note, in criminal prosecution, the presumption of guilt is proof beyond reasonable doubt. Okay, meaning in a criminal case, the evidence is really there must be an assurance that the person committed the offense. That's why the requirement is the highest standard in the conviction, a proof beyond reasonable doubt. A proof beyond reasonable doubt simply means that there's indeed no doubt at all that you committed the offense. Because if the guilt is equal, when the evidence is equal, like guilty and not guilty are just evidence of guilt and the evidence of not guilt is just the same, then the court will decide in favor of the accused. Okay, that is the meaning of equipoise or equiponderance of evidence. In civil cases, the requirement for the conviction or for the winning of the case is preponderance of evidence, meaning based on evidence. In criminal prosecution, the requirement is proof beyond reasonable doubt, even if without evidence signed. But if it can be ascertained that indeed person committed the offense without doubt at all, then there is a conviction. Because if there is an iota of doubt, the court will always acquit. It's difficult to convict a person, an innocent person. It's easy to acquit a guilty one rather than punishing an innocent man. Okay. What do you mean by void for vagueness rule? The accused is denied of the right to be informed of the charge against him and to due process as well. If the law is vague, if the law is not clear, when there is a room for other interpretation, meaning the law is not clear, and what is the consequence? It should be declared void. A person cannot be punished by a very vague law. Otherwise, he will be deprived of his right to due process. So, for example, the language of the law is not clear. Then, well, the person should be released. Okay. Again, the principle is that it's easy to acquit a guilty man than to punish an innocent man. So again, the time when a person meet the witness for the first time is during the arraignment. Now, section 15, the privilege of the writ of habeas corpus shall not be suspended except when there is invasion or rebellion, or when public safety requires it. So there are three instances when the privilege of the writ of habeas corpus, okay, meaning you will be arrested without warrant. That's the meaning of the privilege of the writ. It cannot be suspended. And what are the cases when it can be suspended? There are three. Invasion, okay, rebellion, or when public safety requires it, like riot, for example, you can be arrested even without warrant. Okay, when the president declares the suspension of the writ of the privilege, okay, of a privilege of the writ. Take note, it is a privilege of the writ, meaning you can be arrested even without warrant. So that cannot be, a person cannot be arrested without warrant. When can he be arrested without warrant? In case, or when that privilege can be suspended, invasion, rebellion, or when public safety requires it. You know what's invasion? When other country will come to us and then it's like colonizing us. Rebellion, where rebels take over the government, or when public safety requires, as may be determined by Congress, or any person expert in the field to determine that the public safety requires it. Now, what do you mean by writ of amparo, okay, and writ of habeas data, and another one, writ of kalikasan, which is not here, okay, but just to give an overview so that you will understand what does it mean, as distinguished that from the habeas corpus. Okay, as we know, I already discussed the meaning of habeas corpus. Writ of amparo simply means the overprotection. These are the person whose right to life, liberty, or property is violated or threatened to be violated by the omission of public officer, official, or employee. Simply means that a person who disappeared perhaps because he is accused to be an NPA, and normally this is a crime against a military or peace and order officer working in government. Like for example, the last time you heard of him who is known to be an NPA was in the camp of the military, then the writ of amparo is addressed against the commanding officer of that military camp to secure or produce evidence that they're not responsible. Otherwise, they will be presumed that they are responsible for the disappearance of person. So what do you call that writ commanding them to produce the evidence that they are not responsible? Writ of amparo. Another one, writ of habeas data, a remedy available to any person whose right to privacy or liberty is violated or threatened by an unlawful omission of a public official or employee. Okay, still, but similar to amparo, but this one is to produce the body. Okay, this one is total protection against a public officer. Okay, and then other one, in similar to that, petition for writ of habeas data filed by a member of the immediate family who can file the case against the police officer or military, and then relatives, the consanguinity or affinity.